Good evening, participants. I, Shania Bansal, on behalf of Team Corporate Law Advisor and CII, welcome you all to our session on ADR Live Law Channel. Today's session is divided in two parts and shall be conducted by Vishwam Jindal sir, who is an advocate and specializes in dispute resolution, arbitration, mediation, negotiation, and this is a unique concept wherein our experts will be providing you updates in the field of ADR laws, followed by panel discussion on topics of current relevance. Before we begin our session, I would like to request all participants to please be on mute. During the session, if any participant has any query, feel free to post it in the chat box and it will be duly answered. With these words, I now hand over the dais to Vishwam sir. Thank you.
Thank you, Chaitanya, and good evening, everybody. My name is Vishwam Jindal, as most of you would know if you've been attending the past sessions. I'm the moderator for the entire series, and we've got a packed agenda today, so I guess I will just sort of kick off. I'm just going to share my screen now. Okay, perfect. So welcome to the third edition of the webinar series. Like the first two editions, again, this webinar will be divided in two parts. The updates part, where I would be discussing key decisions of the Supreme Court and High Court on arbitration, mostly this time. And the second part, where we're discussing the grievance redressal process under the new IT rules of 2021 that came into force on 25th February 2021. So very recent and topical. So I guess without further ado, I'll jump in so we can have some more time for the panel discussion. So I'm mainly going to be discussing 4 decisions that you can see on my screen now. And if there are any questions, I think it's probably best if we take them as we go. So if you want to unmute and ask a question, then we can have a discussion on that. Or if you want to put it on the chat box, then Chaitanya is moderating the chat box so we can take those questions there. The first decision is Akshay Aluminium Alloys Limited versus Prasad Commodities Limited, a Delhi High Court decision on the 8th of February. Essentially, the factual background is that Akshay Aluminium challenged an arbitral award under Section 34 of the Arbitration Act, and the dispute arose out of the multi-commodities exchange and 2 circulars. These circulars have actually been challenged and were challenged before the arbitration commenced. Both parties had challenged it before the Delhi High Court as well as other high courts, including the Rajasthan High Court. During the arbitration, Akshay Aluminium had made a Section 17 application to the tribunal for staying the proceedings pending decision of the High Court in the writ petitions. This was, however, rejected by the tribunal as it would have amounted basically to sign die stay or stay until the Delhi High Court decides on the writ petitions. The tribunal rejected it, saying this is not contemplated under Section 17(1)(2) of the Arbitration Act, and even the bylaws of the multi-commodities exchange require the award to be issued within 8 months. So one of the grounds actually Akshay Aluminium argued before the Rajasthan High Court is that the MCX was restrained from taking any actions under the 2 circulars, and the validity of the circulars itself was challenged. So basically, this was the subject matter of the writ petitions before the High Court. Akshay Aluminium also argued that the tribunal did not cite its Section 17 application, because essentially what happened was that when the Section 17 application was made to the arbitration tribunal, they merged it in with the sort of the other entire arguments on merits, and they just issued a final award. So they didn't really issue any partial or interim award or any procedural orders with respect to the Section 17 application. And this was a ground used by Akshay Aluminium to say that this prevented them from filing an appeal under Section 37. So it's a statutory right which the arbitration tribunal took away. The High Court, however, rejected it, says, there were no principles of natural justice which were violated, and the tribunal, of course, had discretion in the matter. Another reason that the High Court held was, it's not really a ground for challenge under Section 34. So the tribunal said, the Delhi High Court said that the Section 34 of the Act permits a challenge to an arbitral award on limited grounds. So basically, it was the Delhi High Court rejected the application. They were saying that the circulars had nothing to do, even though the orders were passed by the MCX under the circulars, they weren't particularly relevant. And even if there are writ petitions pending in the High Court, it basically wouldn't affect the arbitration award. So the arbitration Section 34 application was dismissed, and the Delhi High Court said it's enforceable. I will just move on to the next decision unless there is any question. Okay. The next decision that we're discussing is a Supreme Court decision dated 11th of February 2021 in Chintel's India Limited versus Bhayana Builders Private Limited. Essentially, this was again a Section 34 petition. But just to give you some background, so Section 34 of the Act permits a challenge to an arbitral award on limited grounds within 3 months. And as you know, a 30-day extension is permitted if there is sufficient cause. So you can only challenge an award within 3 months or 90 days, but an extension of 30 days if you can show sufficient cause. Section 37(1)(c), which permits appeals from the orders, relates to setting aside of arbitral awards under 34 as well. And the background to this is that if you know of the BGS SGS Soma case, which we had briefly discussed in the last 2 webinars, the Supreme Court had held that an order condoning delay in filing a 34 challenge is a preliminary order, and so it's basically not appealable. Now, this application was a Section 34 challenge, and as we discussed, the procedural limit is 3 months plus 30 days. So Section 34 was filed in the Delhi High Court, which refused to condone the delay and dismissed the challenge because it was filed after 3 months and 30 days, so after 120 days. The decision was then appealed to the division bench, but because the division bench of the Delhi High Court was bound by BGS SGS Soma decision of the Supreme Court, it dismissed the appeal, holding that an order refusing to condone delay is not appealable under Section 37(1)(c). The division bench did, however, grant leave to appeal to the Supreme Court. What the Supreme Court did now was it distinguished the BGS SGS Soma case, saying that in that case, the delay was condoned and this did not amount to a final decision on the challenge. So the Supreme Court basically held that a refusal to condone delay would be a final decision since it results in the challenge being dismissed. Such orders are therefore appealable under Section 37(1)(c). The court also said that Section 37(1)(c) says setting aside an arbitral award under Section 34 basically would amount to an appealable order under Section 37. And this would include dismissal of a challenge not only on the merits, but also on the grounds it's delay. And for this, they basically placed reliance on decisions under the 1940 Act, where Section 39 of the Arbitration Act 1940 was basically in paramateria with Section 37 of the new Act. And the court also reaffirmed the position that Section 5 of the Limitation Act does not apply to Section 34 challenge, and therefore, if it's beyond 120 days, then you cannot file an appeal generally under Section 37. Is there any question on the first 2 decisions? Okay. The next decision is Bhavani Construction through Premji Bhai Kesha versus Executive Engineer Sardar Sarovar Narmada Nigam Limited. Again, a decision of the Supreme Court passed on the 6th of January 2021. Essentially, the factual background is that it was a contract to manufacture and supply bricks by Bhavani Construction, which was the contractor to Sardar Sarovar Narmada Nigam Limited. Now, the contractor initiated an arbitration because there was a payment dispute. The Arbitration Clause provided for an arbitration under the old Act, so under the Arbitration Act 1940, or any other statutory modifications thereof. The respondent informed the contractor that Gujarat had a specific specific law, which is the statutory modification, which would be covered under the Arbitration Clause. And that's the Gujarat Public Works Contracts Dispute Arbitration Tribunal Act of 1992. So basically, Sardar Sarovar Narmada Nigam Limited said the arbitration should be under the Gujarat Act of 1992 and not under the Arbitration Act of 1940. But the contractor nevertheless proceeded, and they appointed a sole arbitrator under the 1940 Act. The respondent then moved a Section 16 application before the arbitrator, challenging the jurisdiction, but this was rejected. The respondent then filed a special leave application before the Gujarat High Court under Article 226, 227, but the single judge dismissed it, holding that the respondent's remedy was to challenge the final award. So it couldn't do anything else as an interim measure. Their only remedy was to challenge the final award. The respondent then filed a letters patent appeal before the division bench. The division bench allowed the appeal and held that the contract was a works contract. So it was specifically covered by the specific Gujarat Act, and the applicant could not have appointed a sole arbitrator. An SLP was filed to the Supreme Court by the contractor, and the Supreme Court framed the issue saying whether the arbitral process could be interfered under Article 226, 227 of the Constitution, and if so, then under what circumstances. The appellant then submitted that the division bench of the Gujarat High Court had erred in interfering with the single judge's order, and the fact that the final award was passed by the sole arbitrator, which it was when the SLP was filed, was now challenged under Section 34. So there were basically two parallel proceedings. One was this proceeding, which had come from a single judge High Court, then letters patent appeal to the division bench and now to the Supreme Court. And in parallel was a Section 34 challenge application. So basically they said, there can't be parallel proceedings. The only remedy is to go under Section 34. The third argument was that Section 16(2) of the Act mandates that the sole arbitrator jurisdiction, and that can only be challenged under Section 34. The respondent then basically submitted that since the enactment of the Gujarat Act, the Arbitration Act was substituted, and basically the Gujarat Act would then be applicable. And in Articles 226 and 227, it was always open for the respondent to invoke the jurisdiction. The Supreme Court allowed the appeal and basically set aside the order of the division bench, and it held a couple of points. It said that the respondent had not challenged the appointment of a sole arbitrator, and there was no bad faith or exception circumstances to invoke 226, 227. So the Supreme Court held that the Arbitration Act is a complete code essentially, and unless there is any bad faith or exception circumstances, the High Court or the Supreme Court should not intervene in their jurisdiction. They also held that it was basically a matter of contractual interpretation on whether the Arbitration Act of 1940 applies or the Specialist Gujarat Act applies, and that it was for the arbitrator to decide and not the High Court and the Supreme Court. Sorry, I know I'm sort of rushing through these decisions, but are there any, should I take a pause to see if there are any questions? We've not got a very big audience in Zoom. I don't know, there must be more people logging in from YouTube. No questions? Okay, then I'll move on to the last decision before we kick off the panel discussion. So the last decision is a decision of CS Electric Limited versus GOP Power by the Delhi High Court. Decision rendered on the 29th of January. Basically, the contract was for the petitioner to supply sandwich bus ducts to the respondent. And I want to read out the arbitration clause because I think it's quite relevant and important based on what the Delhi High Court decided. So the arbitration clause basically states, all disputes shall be resolved through arbitration. The appointment of a sole arbitrator to be selected by the supplier manufacturer out of the names of 3 such notable persons to be given by GOP within a period of 30 days from the notice of reference of unresolved disputes between the parties. The jurisdiction of holding the proceedings of such arbitration shall be the state of Delhi, so the seat was Delhi. The applicable law will be the Arbitration and Conciliation Act. In case the supplier manufacturer fails to choose the name of the arbitrator from 3 names of arbitrators suggested by the GOP board, The GOP board reserves right to appoint an arbitrator of his choice, and the supplier manufacturer shall be bound by such arbitrator and his award. So the facts are actually quite similar. So on 26 November, the respondent proposed 3 names because it wanted to start arbitration and invited the petitioner to select an arbitrator. The petitioner did respond, but on the 4th of January, so that's after 30 days, and it selected O.P. Bhatia, which was one of the 3 names that the respondent had proposed to act as an arbitrator. But by then, and on the same day, the respondent sent a letter to the petitioner saying that it had already appointed Mr. J.K. Farlia, which was also one of the 3 names, to be the arbitrator, and that he had accepted his appointment. The High Court then held that the appointment of Mr. Bhatia cannot muster as it was effected beyond the period of 30 days as stipulated in clause 15.3.1 of the agreement, and was therefore in violation of the terms of agreement between the parties. So essentially, because the selection was not done within 30 days by the petitioner, Mr. Bhatia could no longer be appointed as an arbitrator because it was not strictly in compliance with the Arbitration Act. The High Court also rejected J.K. Farlia's appointment, even though the arbitral clause, as you may remember, strictly says that the board reserves the right to appoint an arbitrator if the other side does not pick it within 30 days. And while doing so, the High Court relied on the landmark Perkins-Eastman decision and the HSCC decision, which basically says that if it's a sole arbitrator, one party cannot pick it. Basically, the only remedy is to either go to the court or to go to an independent arbitral institution for the appointment. So on the basis of section 12.5 and schedule 7 and these decisions, the High Court rejected both arbitrators. And the High Court held that the Supreme Court had in these decisions clearly discountenanced conferment of any authority on either of the parties to the agreement, either to act as arbitrator or to appoint the arbitrator to arbitrate on the disputes. So I guess that was the first part of our webinar in terms of updates. If there are any questions on the updates, probably a good idea to discuss them now before we move on to the panel discussion. No? Okay. I guess then we can kick off with panel discussion. I can see one of our panelists, Mr. Jay Krishna, is here. I think we're just waiting for the other panelist, Arjun, but I can kick off with a brief introduction to the topic, and then we can sort of discuss it. So today's panel discussion is basically on the newly notified Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. We won't be covering the entire framework of the rules. Our focus will specifically be on grievance redressal and dispute resolution within these rules. So I will probably ask the panelists to introduce themselves, but I guess we'll just wait for Arjun to join us, and then I can ask them to introduce themselves. But before then, I guess what I'll do is I'll run through the, sorry, is my screen no longer being shared? Yeah. So I guess I'll briefly run through this first before we move on to sort of discuss with the panelists. So the IT rules have basically been passed under section 87(2)(1)(ZZG of the Information Technology Act. It's got 3 parts. Part 1 is preliminary. Part 2 applies to intermediaries, and that's basically covered by the Ministry of Information and Technology. And then part 3 applies to digital media, which is basically covered by the Ministry of Information and Broadcasting. And they were notified on the 25th of February, 2021, like I said. So briefly, the grievance, so we're discussing part 2 first, which basically applies to intermediaries Basically, what the rules say is that there has to be a grievance redressal officer that is appointed by each intermediary, and there is an intermediary and a social media intermediary and a specific intermediary. And the names of the grievance redressal officer and contact details have to be put up on the websites and the mobile applications. There is a grievance redressal process wherein if anybody files a grievance, it has to be acknowledged uh, within 24 hours. So if I were to file a grievance today, the intermediary will have to acknowledge it within 24 hours, and then it has to be disposed of within 15 days. There is a special mechanism for complaints in respect of nudity, depiction of any sexual act, impersonation in any electronic form, or artificially morphed images. So such complaints have a specialized mechanism in which they have to be dealt. And like I said, there is a more onus burden on significant social media intermediaries, which have to have a resident grievance redressal officer, and each intermediary have to publish a monthly compliance report, which is also sent to the government, but also published for the public at large. The significant social media intermediary, the mechanism is for the complainant to track the status by providing a ticket number. So every time the complaint is lodged and acknowledged by the intermediary, there has to be a ticket number through which you can track what the progress is within the 15-day period. And when a decision is given, reasons are to be provided. And so there are additional rules, like I said, which apply to significant social media intermediaries, which generally don't apply to intermediaries. But if the ministry notifies, then the other intermediaries also have to follow the more onerous rules on significant social media intermediaries. Now, there is a special clause 4.8 procedure for intermediaries. It'll probably be helpful to read it out. So essentially, where a significant social media intermediary removes or disables access to any information, data, or communication link under Clause B of Subrule 1 of Rule 3 on its own accord, such intermediary shall ensure that prior to the time at which such intermediary removes or disables access, it is provided the user who has created, uploaded, shared, disseminated, or modified information, data, or communication link using its services, or with a notification explaining the action being taken and the grounds for reasons of such reason. Ensure that the user who has created, uploaded, shared, disseminated, or modified information using its services is provided with an adequate and reasonable opportunity to dispute the action being taken by such intermediary and request for reinstatement of access to such information, data, or communication link, which may be decided within a reasonable time, and ensure that the resident grievance officer of such intermediary maintains appropriate oversight of the mechanism for resolution of any disputes raised by the user under Clause B. So essentially, if you are an intermediary, a grievance is being filed over some content and that's being taken down, then you need to give an opportunity to the person who has uploaded or created or shared that content. And if he disputes the decision, then he needs to be heard before it's taken down or after it's been taken down to either reinstate the content or permanently remove it. So this is a sort of special mechanism which I refer to as the Clause 4.8 procedure under the rules. I think before we move on to the next part 3 grievance redressal, I think it's probably a good time to introduce the panelists. So I will welcome Mr. R.J. Krishna, Secretary General of the News Broadcasters Federation here. I think our second panelist, Arjun Sinha, should join us soon. But Jed, do you want to introduce yourself?
Thanks for the opportunity, Vishwam, and the people. Nice to meet you in this forum, and a very, very relevant and an important, crucial topic at this time for the media companies or anybody who's a content creator with the new digital media ethics code coming to be. So I'm Jay Krishna. I lead an organization called the News Broadcasters Federation. It's essentially a joint industry organization founded and funded by television news channels across the country. And we have a self-regulatory organization called now the working name is called the Professional News Broadcaster Standards Organization, where we are adopting the best of the practices, the new age we did anticipate these kinds of rules, and we had already tied up with Vibnyai, Vishwam, to address what could be the forthcoming compliance requirements as far as the grievance redressal mechanism is concerned. That's a short about me. I'm happy to answer any questions or queries people might have.
Thank you, Jay. I think we can introduce Arjun when he comes, but would you prefer I go through the redressal process for publishers and OCCs before you?
Please do.
Okay, perfect. So part 3 of the rules basically applies to publishers, so digital news media outlets, OTT platforms, and online content curators. So this would basically cover any current affairs content, any publication which publishes current affairs content, all your OTT platforms, the likes of Netflix, Amazon Prime, Hotstar, Z5, etc. And attached to the rules is also the code of ethics, which is appended to the rules. We won't be going into the code of ethics in detail, but we'll just be discussing grievance redressal in as far as it relates to a violation of the code of ethics. So there is a sort of a new 3-level grievance redressal process which the ministry has set out. The first level is just self-regulation. So the publisher or the OCC platform itself answers a grievance. The second level is where the SRO or the self-regulatory organization comes into the picture. And the third level is an oversight mechanism by the central government. So at the first level, it's basically very similar to how it's in part 2 for intermediaries. There has to be a grievance redressal officer resident in India, and the name and contact details of the officer should be mentioned in the website and any mobile applications. The process is again that if you file a complaint, it should be acknowledged within 24 hours. So if I were to file a complaint against, say, Netflix grievance redressal officer should basically acknowledge the complaint within 24 hours. And then it has to issue a decision within 15 days of registration of the grievance. If no response is received or if unsatisfied, then basically you can raise it to level 2, which is the SRO level, which I'll discuss shortly. And again, if you don't receive any response or are not satisfied with the decision of the SRO level, at the SRO level, then you can raise it to level 3. And we'll come to Jay and Arjun to sort of discuss this in practice. But before that, I just want to take you what actually the law or the rules set out. So at level 2, there is an SRO, self-regulatory organization. And the intention is that it will set up a tribunal which is headed by a retired Supreme Court or High Court judge or another independent eminent person. And it comprises not more than 6 members. So there are 7 people in total at the maximum, 6 members and a chairman. The SRO has to be registered with the MIB, with the Ministry of Information Broadcasting. And it's one of the functions that the SRO should do is to basically resolve grievances. In terms of what powers the SRO has, it's very interesting. So the SRO, while disposing of a grievance or an appeal, may issue following guidance. So it's basically guidance that the SRO can issue. The first one is warning, censuring, admonishing, or reprimanding the publisher. It can require an apology by the publisher. It can require the publisher to include a warning card or disclaimer. In case of online created content, it can direct the publisher to reclassify ratings. So the code of ethics, which are part of the rules, does have various ratings on how the content should be rated. The publisher can also be directed to make appropriate modification in the content descriptor, age classification, and access control measures. And a synopsis of relevant content can be edited. In case of any content where it is satisfied that there is a need for taking action to delete or modify the content, preventing incitement, the commission of a cognizable offense, then basically it can be referred to the ministry and it directly goes on to the oversight mechanism, which I'll come to now. So at the third level, we have the oversight mechanism. Essentially, it resides at the ministry level. So the ministry said it will publish a charter for the SROs, including a code of practice for such bodies. It hasn't been published yet, but it should be out hopefully soon. And it will also establish an interdepartmental committee for hearing grievances. So it basically, refers to this, if we call them IDC, Interdepartmental Committee, grievances arising out of the decision of the SRO. So any decision at level 2, or where no decision has been taken at the SRO level within the specified time period. So then you can directly come to level 3. It will also issue appropriate guidance and advisories to the publishers and issue orders and directions to the publishers for maintenance and adherence of the code of ethics. The MIB will also essentially appoint an authorized officer, which will not be below the rank of joint secretary, and the authorized officer will be the chairperson of the interdepartmental committee. So the committee will meet periodically, and we can discuss this during the panel discussion on how that would play out. But essentially, it will hear complaints regarding violation of the code of ethics, which again, like I said, arising out of grievances of the level 1 or level 2, or where no decision is being taken at the level 1 or level 2 within the specified time period, or thirdly, where it's been referred to the ministry at the SRO level. The rules do say that complaint should be received in writing and sent by either email or fax. So it doesn't contemplate complaints being sent by post, doesn't expressly say so. If it receives complaints by email, it should be signed with electronic signature, and all complaints, then once the ministry receives it, they have to be numbered and provided a reference. And the reference should state the date and time of receipt. Once it does receive a complaint, it has to basically send notice to the defendant, so the publisher or the online content curator. And once it hears the grievance, it can basically make recommendations to the ministry. Any recommendation that it makes will essentially have to pass the eyes of the Secretary of the Ministry of Information and Broadcasting. So no action can be taken before it's approved by the Secretary. But recommendations can be in the form of issuing a warning, censuring, admonishing, or reprimanding such entity, requiring an apology, and requiring such an entity to include a warning card or a disclaimer. It can also be for an online content curator, it can be basically reclassifying ratings of relevant content, editing synopsis of the relevant content, or making appropriate modification in the content descriptor, age classification, or parental or access control. And it can also be in terms of deleting or modifying content, which basically incite violence or encourage commission of a cognizable offense. And then the last one on section 69A is similar to what we saw at the SRO level. So essentially, that's what the rules say. We've also got a second panelist, Arjun, now. Hi, welcome, Arjun. Do you want to quickly introduce yourself?
Hi, Vishwam. I am Arjun, and I'm a lawyer at a firm called APN Partners. And we look at a lot of these issues for technology companies. And in fact, the last few weeks have been busy because everybody's asking questions on how to comply, what kind of grievance redressal frameworks do they need to set up. And in fact, there's a lot of other systems and processes that need to change. So look forward to discussing all of that now.
Thank you. So we've just discussed what the rules are. Jay, do you want to go first and tell us your take on these rules?
The prima facie setting out a framework on guidelines on rules is good, but I don't want to be a cribbing baby here, but government should have consulted the industry at large, and especially the stakeholders, the two stakeholders, right? The content creators and the content consumers. That somehow seems to be missing. And the current system of regulations is something which is already existent with the, especially with the broadcasting industry. The news broadcasters have it. So does the content creators in the general entertainment, which is the BCCC Broadcast Complaints, Content Complaints Council with the IBF, right? But the three levels, like the onus is on the content creator. That's the platform, be it the television, especially with this the web. So the person who's going to host it, that's where the liability. There's 15 days. So there's an ambiguity. What do they mean by 15 days? Is it 15 working days from the date of the complaint to address, and what? And what about the grievance redressal officer, right? What is the liability, right? And often the GR, who's usually the legal counsel or the legal head, a lawyer, that has to be defined. There are a lot of these gaps, which could actually, the intention is good, but it could derail the entire process of a grievance redressal. right? That's my primary take on it. And more than just the 3 levels, they should be looking at least a 5-level process. With now looking at the Supreme Court looking at a mediation at a pre-litigation level before they comes to the courts, they want to reduce it, right? That is, keep it one side on the thing. And next is when it comes to the grievance or whatever they classify as a grievance on a content, it is just not the content, there is also context to the content, right? What I might see, what a content for me could be good may not be the good for some other people. So that is one. And what happens to content which is already out there? Unlike the many other media, right? The television, you see it at that point of time and it goes. You're not going to watch it again. So that's a push content. Primarily, the internet, the web is a pull content. Imagine if you're going to watch a show which is about 5 years ago, which you can access on any of those platforms or on the web, and you object to it. What happens if there is a new complaint on a very old content? How are we going to deal with that? And are we going to also, like in the broadcasting industry from which I come from, we at least have something called the programming and content code. We've defined about 9 sets of these could be the violations. Are we going to list out those violations, right? So that's one more point. And if we could have a very simple grievance redressal process which is online, completely online, right? You can integrate your mobile and your apps to an online system and have this 5-level systems, right? Which the person who's aggrieved wants to complain doesn't have to refile the same thing again and again, right? So he files one complaint, it moves on to various levels, and the entire process, what I would suggest is a very democratic and a very time-driven process. It should be about 6 months or 3 months, whatever they decide, right? So the honest here is 15 days for the platform. What happens to the next level? You're not defining it, right? So in the broadcasting industry, I could tell you, we've had instances where there have been violations or so-called content violations, and there's a takedown order, a shutdown the channel order after 2 years. It doesn't make sense, right? It just doesn't make sense, because under the Cable and Television Act and the Doubling and Downing Act, we can, the broadcasters or the content producers are supposed to hold the content only to a period of about 60 days, right? And if I want to go back and view that content, I don't hold it. I'm not required by law to hold it. So there are a lot of these gaps. I think there should be an open public consultation involving the platform where the actual grievance comes in, the content creator, right, and the viewers. There are many civil rights offices. The government can call in all those, put up an open consultation, more fine tune it. Right? And also, I think there should be a pre-litigation mediation after the grievance level. At the platform level, you have the grievance officer define who's going to be a grievance officer, define what is the liability and what is the protection from law are you going to give the liability. Like, they are not a key management personnel, and unlike what the SEBI gives you a protection under the Listings Act or the Companies Act. So that is very crucial. So I leave it at that. I leave Arjun to continue with the other pointers.
Thank you, Jay. I think I'll come back to you on a couple of those points. But before that, I want to let Arjun give us some thoughts on the new rules and the grievance redressal process in these rules. You're on mute.
Yeah. I think I'll just keep it short. The issues are many. But on the intermediary side, the first question is, who does it apply to? Because there's a definition of significant social media intermediary, and they seem to indicate platforms like Facebook, etc. But there is a draft that was made available, and sort of various newspaper channels reported it. And that definition of significant social media intermediary excluded platforms like e-commerce platforms, and there were some exclusions there. Those exclusions are not specifically there in this definition now. So we don't. I mean, does that mean that some other platforms, maybe such an e-commerce platform, etc., are also covered by this definition? Because if you see the definition of social media intermediary, it just means any intermediary that enables online interaction between 2 or more users and allows them to create, upload, share, disseminate, or modify information. So that could easily be even, say, somebody says, here is a picture of a mug, we want to buy it, and then they communicate and then they buy it. So that clarity was given in the previous draft that no longer exists. The second question is that with respect to the rules and on how the grievance redressal works on the platform side, in addition to before even grievance redressal, it now requires, by some of the rules that have been changed, platforms to also build teams internally to be able to review this before even a complaint comes. So say, for example, do some fact checking, take some actions with relation to complaints. And that's important to, even before you even get a complaint, you have to build that capability because the rules seem to require that of you. The second part is, how do you react to a rule? So if you see, there is this one clause that says, if you don't adhere to these rules, you will no longer be considered an intermediary, and that means you are liable for whatever is, consequent liabilities in law. So how will this change a behavior of a commercial organization? Will they say, okay, I think this was, I don't even want to get into it. If there's a complaint, let's take it down. On the broadcast side, there has actually been a lot of litigation in the past where, broadcasting companies have stood their ground in many situations and said, this is fine, we've taken a look at it, we have a system and process internally, we've reviewed it, and we'll let it stand. So that is one side on the platform side. On the online curated content side, the first question again comes as definition. If you see the definition of online curated content, it says audio visual, and then it says including podcasts. So that means only audio. So like, do we talk about even audio platforms are included, or are we just talking about Amazons and Netflixes of the world? And the clarification from the government seems to indicate it's only the Amazon and Netflix of the world, but that's not how the rule is written. The clarification has no binding in sort of value in law. It's just sort of indicatory and supportive. The second bit is, and this is actually something that's playing out in the courts right now, which is that these rules on the curated content side have actually been, they're not platforms, they're not intermediaries. They actually make an active decision and put materials out there, right? So in that situation, where does the rule-making power come from? Just as a lawyer speaking, right? And that rule-making power comes from, in at least according to the rules, from section 69A, which is the power to block. Now the question is, 69A gives the government the power to block. Does it give the government the power to frame rules to create a self-regulatory organization? Does it give the government the power to create, ask for modification or editing of content? So these are questions that will be asked, and there will be push and pull. On the other hand, there was a fairly elegant process that was there on the broadcasting side, where there was no rule per se, there was no statutory requirement, but people got together. And then, as that system evolved and more members joined various organizations, it started getting due recognition by the court, saying that, legal liability aside, some issues have been dealt with by these bodies, so we don't need to get into it again, right? And therefore, that system evolved over time, that system matured over time. In fact, that we were seeing that, that system was even being proposed on the OTT side, which has now become sort of, mandated by law. So apart from the fact that there can be legal, and there are ongoing legal challenges to the rule-making power in the first place, but there was sort of measures being taken by the industry to sort of get together and do some of these things proactively, which now may see some hindrances. So that is another concern on the grievance redressal side.
Thank you, Arjun.
Just to intervene here, the most important thing is who's going to fund this compliance? Compliance comes with a cost, right? Who's going to fund this compliance is a bigger question, because today it is anybody can be a content creator, right? Somebody who's got a smartphone and as less as a 1 GB data, which comes at a couple of $100. You're a content creator, you're put out there, and there are actually people, the so-called influencers and these video creators and content creators, podcasters, who come from everywhere. You're actually hitting in the hair. You don't know who are you going to target with. I mean, do you actually think these guys can, these small content creators, I don't say small because their nature might be small, but the scale is really global. They have a couple of million followers. Even the definition says anybody who's got a 50 lakh plus, that's about 5 million, is considered as a to be liable under those rules?
No, you're right. Actually, the definition for content creator does not have a 50 lakh threshold. It says it does not include individuals who are not doing this in the course of systematic business, professional or commercial activity. But would that mean that it does include individuals who are doing it as a business?
So that's an ambiguity there, right? So, but there's going to be a huge cost on this compliance, right?
So what do you think is really the scale? Is it going to be like affecting, companies across the board, like Arjun said, podcasters, people on Clubhouse, opening podcasts on Google Podcasts, Apple Podcasts? Is it going to be, digital publications, even international publications like, say, the FT, New York Times, who have a massive readership in India? So what's really the scale that we're looking at in terms of compliance here?
So compliance will be by the willing is what I usually say. So people who think that they are, the rules need a little bit more sort of fine tuning in terms of clarity on who they're applicable to. And they've currently been drafted in slightly broad based, but they will be applicable to the entities that you're talking about, right? While the intention may be to govern audio, video, OTT players, on the curated content side, the definition is slightly wider. So maybe there is more clarity within the rules that need to, by way of clarifications, need to be brought in, so that they can provide guidance on who they cover. But yes, podcasts platforms are covered. On the intermediary side, Clubhouse is covered right now, right? And if they meet the 50 lakh threshold in India, they will be covered. Registered users, definitely. So that is effectively what's going to happen. For a lot of people who are becoming, just starting out, they might actually take a call and saying, "Theek hai, we'll see when we see," and then something bad notice comes, and then something comes, and then everybody grapples around, because that is realistically what is going to happen.
Yeah, and I guess that comes back to the point that Jay was making, who's actually going to pay the compliance cost, because I imagine there must be so many of these international apps which have an audience of more than 50 lakhs, but they probably have no office in India, and you need to have a resident grievance redressal officer in India. So if you don't have an office in India, are you just going to set up an office only to have a grievance redressal officer to comply with these rules, or how would it really play out in practice?
Yeah, so the issue is, and Jay has more practical experience than I do in dealing with some of these issues, but it has to be, for example, your chief compliance officer has to be an employee. You can't contract it out. So, for example, if you see data protection rules in Europe, right, they'll say that you have to have a DPO and you can contract it out. You can identify like a law firm, or you can identify an agency and say, this is the guy, he's going to be my privacy officer. If you have an issue, send him a notice. That's not the case in India. And with a 50 lakh registered user base, it's not that big. We all know 5 million registered users is not difficult to reach these days. So they will have to look into it and comply with it. What happens if you don't comply with it? Honestly, I think if you don't comply with it, then you could face a blocking action against you, because if it gets flagged, government sends you a notice, you don't respond in time, or you don't respond positively, you could see action being taken against you, and not being made available to Indian users.
Arjun, Vishwam, just to step back, that was a quite interesting thing that we are actually looking at these rules on a traditional media sense. So this is a quick wet question. Can we imagine who's the largest content producer in the world? Just a wild guess. You guys can take a wild guess between Vishwam and Arjun or any of the audience, right? You might think it's Google, YouTube, Amazon Prime, Netflix, or Universal Studios. None of them. The largest video producer in the world is a group called Hyatt. It's a hotel chain. They create more videos to engage the consumers, right, on the travel front than any of these platforms. Are they going to be liable now? One, in the Indian context, I'll tell you, the largest media organization on the web hits a monthly average user of about 5 million. But one steel company about 8 years back decided not to go to the traditional media. They have their own media, which is the podcast. The chairman talks to the shareholders and the stakeholders on a podcast, on a video, on interactive. So they have about 8 million. So are they going to be covered? they do technically fall under this. Or let's take the case of Flipkart, right? Flipkart again decided not to go through traditional media. Flipkart has its own newsroom. They employ journalists. They have their own blogs. They have their own podcasts. They would create their own content. Yeah, but that's pushed towards selling their products or talking nice things, right? But how are we going to deal with these kinds of new age content company? Because today commerce sells on content.
Yeah.
Right? So are we entering this case of what happened in the Europe with the GDPR? So you release a law and everybody has to comply, but no one has a clue how to. Right. So that's exactly what we are looking at. So
you're right. I mean, the intention seems to be trying to regulate a platform with like Netflix or Amazon. I mean, these video OTT players in mind. But I think the language of the rules might, encompass any of the guys you were talking about, because all of these guys could be seen to be, a publisher who is performing a significant role in determining online curated content and is making it available to users on a computer resource.
Yeah.
Right. So, I mean,
they fall under the definition.
Right.
They do fall under the definition of these new rules.
Correct. And yeah.
Sorry, go on, Arjun.
No, that's it. Please go ahead.
Yeah, sorry.
I was just going to ask you, what do you think would make a good sort of grievance redressal officer? Like, what qualifications do you think companies should look at when they're picking a grievance redressal officer?
And this one's for Jay.
No, I think we are going to be on two extreme ends. So I would hope that Arjun says somebody with a legal background. I would say somebody with a content background, right? Because and who has knowledge of the media law and how it operates. Because content, we can't be. It's in a new modern society. We can't be restricting content. We can't be censoring content. If you're going to restrict the content, there's something called VPN. People are anyway going to watch it, right? So it's better to be open, right, and have a content person who trained in law, or a legal person. I would prefer a lawyer who's got a strong foothold in the TMT laws, who understand the nuances law, but understand the content side of it. Because content doesn't stand alone. Content comes with the context. Why is that particular information, dialogue, or something which is being put out there, right? So that is the very critical thing. In the broadcasting world, many of the times there's been we have this order saying shut down your channel, take it off air for 2 days, 3 days, 7 days, whatever. The order comes at 4 o'clock typically. By 6 o'clock, there's a stay order by the Delhi High Court. The courts understand, right? But can we prevent that kind of action? So it's not going to be that easy to implement. Right? And there's a lot of, even when you take off, there have been instances where a lot of channels were taken off air. But look at the economic value of it. How many people are going to be jobless for those 3 days not producing content? Can we look at a more civil way of looking at it, right? In fact, interestingly, China does that. China gives 6 hours to take down the content, also even Singapore for that matter. They explain to you, the government or whoever the officer sends you a notice, explains to you the other side of the story, why they think it is right or not. You can contest in the court, or you can put it out there on your web or your video and saying, this is what we published and this is what the government authorities think, which is a fair play, right? And obviously without context, any content, I mean, what could be good for me could be bad for anybody else.
No,
I mean, but a content person with a knowledge of the law is very, very critical to be a grievance officer.
No, the only thing I'll say is I agree with you. And in addition to understanding content and maybe the law, that person needs significant risk appetite and an ability to withstand difficult conversations. But more importantly, on the timelines bit, I think the rules don't change much. I mean, it used to be 36 hours earlier. Now it's 36 hours now. And blocking powers, there is, even in emergency situations, you have 48 hours to comply with. So those timelines are given. What has changed in terms of timelines, I think, is earlier for grievances, you were allowed to take an action within 30 days of the complaint. Now Today, as on today, you have to do it within 15 days. So that timeline is actually reduced. Earlier, in 2011, I think there was a clarification by Modi which said
Just,
that you had to respond in 30 days. And
Response
acknowledge.
time.
sorry, I just had a question on that. So recently, the Editors Guild of India said 15 days is very onerous. What do you think about that? Is that reasonable? Is that onerous? What should it be ideally?
I mean, I haven't had a practical experience. Jay would have, but it depends completely again on the context, right? Like if you get, for example, 50 complaints and you have to actually review them and you have to take a just decision on it. Maybe it's not enough, but I can also understand the other side. If there is something that is significantly problematic, and given the pace at which information flows on the internet, even a day or even an hour can be a bit much. So that's not really an easy answer to give. To give.
But just to draw a parallel, I think they should actually define it as 15 working days if they want to actually have or they could say up to 15 days or a minimum of 15 days. So these jargons of the legal world, so which keeps us a little at bay from litigations. Let's draw a parallel to something what used to happen in the Doordarshan days, or what used to happen, what still happens in the newspaper world, right? So if I have an issue with the content which is published in the newspaper, I raise a grievance, so which appears the same day next week or the week after, which is within the fortnight, 15 days, which is what this rules. And that is something called as the letters to the editor. It still exists in all the newspapers, right? So the grievance redressal has been there. We could actually take a best practices from there. On the digital world, I think, they should tweak it to either 15 working days or a minimum of 15 days. And they should explain the escalation matrix also. What happens after that?
The other thing is, we must not forget that while intermediaries have protection from liability, and therefore, there is need for transparency in how they deal with some of these complaints, publishers are actually liable for what they publish.
Yeah.
The laws of there is no safe harbor for them. So, if they are putting out a piece of paper, if they're putting out a piece of video, does get vetted through legal teams. It does get analyzed on where the boundaries in Indian law lie, and then they pass through. And if somebody has an issue, which people often might, they have full ability to go to and take action. In fact, the rules themselves say that by following these grievance redressal systems does not mean that your liability under other areas of law you're absolved of those liabilities. So which is why in some of these situations, and as in the broadcasting scenario, a self-regulatory framework works, right? Because you decide between yourselves on how to implement checks and balances and then move ahead, as opposed to there being a mandated process in which you comply with it, but the upside may be limited for you. Because you can still have to go to a thana when you have an FIR and then present yourself and answer a few questions.
Yeah, that's true. And picking on Arjun's thing, what happens to the liability of the grievance redressal officer? Does he go to jail because some executive producer decided to put some content contracted to a third-party agency? So I think they should not look at it at a very narrow level. They should look at even at the Companies Act. Bring in the grievance redressal officer or the compliance officer as a key management personnel. Give him that legal protection. And especially talking in a country like India, I could be sitting in Gurgaon, but I could face an FIR in Guwahati and potentially get arrested too. And that's happened in a lot of cases, right?
Yeah.
So that has to be sort of, there should be some levels of checks and balances, right?
Yeah.
And here also, it's rather than straight away, one thing which at our self-regulator, which is the Professional News Broadcaster Standards Organization, which we're thinking as what happens the first level of grievance before the SRO, right? But after the broadcaster or the content company or the platform is, we thought under the Cable and Television Act or any of the so-called Media Act, excuse me, the district magistrate is authorized. So he could review it.
Yeah.
Right? He could review it and probably, technically these are IAS officers who reported to the central government, to the cabinet secretary. They could send a report. They could send out a technical, what they think to the MIB, or the MIB can ask them for these reports. what do they think? And we need to understand what is the scale at which we are talking. We are talking about 30 plus languages and dialects. We are talking a country of almost, we're reaching 1.5 billion. What you're going to address is just not in Delhi. It's just not in a couple of languages, right? It's huge, it's massive. We are talking about communities, we are talking about communal sensitivities, we are talking about languages, traditions, culture. We're talking about a whole lot of things when you're actually talking about that context. That has to be brought in when these, I appreciate the rules. Now it's in the courts of law. The Supreme Court has upholded when they're going to take up the bunch of petitions, various high courts. So, but they should look at all these cultural contexts, all these contexts put together in a wholesome, and then see how it can be addressed.
Yeah. No, just picking up on that. Thank you, Jay. Arjun, do you want to tell us what's really been different decisions? So I know the Supreme Court has stated something, high courts have stated. Do you just want to clarify what the position is now for the audience?
So now, as of now, a few independent actions have been taken on the news side. There was already a matter that was being decided with respect to a criminal complaint on the video content side. The Supreme Court made certain observations on the IT rules on that front. But specifically after the IT rules were framed, one set of entities challenged it in the Kerala High Court, and another set have challenged it in Delhi. And right now, the challenges seem to be not sort of only personal to the entities who petitioned. So they're saying that we qualify as X. We don't think XYZ is valid and should be upheld. And since we are challenging it, we don't want any negative or coercive action being taken against us till this matter is decided. But as and when few more of these matters mushroom, it is likely that they might all get clubbed together and then heard by the Supreme Court after a few orders come on some of these matters, and then sort of either at a high court level or Supreme Court level, the legality of some of these will start getting challenged and questioned, and we may see some rebalancing of some of these provisions. There is a need, I will say, to provide a way for consumers to give voice to their grievances. And a way for these organizations to absorb those grievances and sort of relook at them, because what might work in the US or what might work in the UK may not work here, and it may be in some cases it should not work here, right? But there needs to be more sort of as Jay put it, a civil way of sort of having this discussion, having this engagement, and this process to flow.
Let me quickly answer. Saloni, one of the audiences, had this question of raising a complaint, and they send a templated, the platform send a templated answer or on a content we find objectionable, which you find objectionable, which others may not, because they comply to the country of origin. So that's primarily one thing. What is objectionable in India may not be and is necessarily not objectionable in the US. So this is a debate which has been happening right from 2011 when India had this issue of social media platforms. The next thing, what you could, Saloni and others, if the grievance officer doesn't respond, you could always raise it up to the ombudsman. There is a compliance officer in all the platforms who handles at the global level. You could what they call it, raise a ticket. If you're not happy with the platform or the individual thing, you can raise it out to their higher officials or the manager or the compliance officer at that level, or you could write to the country head of your country, wherever you are. I think, and if you say this is my justification, I think this content is objectionable, but I've not got a satisfactory answer. Further on, the law is open. The doors of the courts are open.
Thank you, Jay. I was just going to come to that. Saloni, if you have any follow-up question, feel free to sort of unmute and ask. Or if there's anybody else from the audience who has questions, I think the floor is open. Feel free to put something in the chat box or unmute yourself and ask your question. Otherwise, I was going to move on to a little more into the details of the grievance redressal process. So in terms of best practices, what do you think? Are grievance redressal mostly just documents only, or should there be an opportunity of being heard both at the intermediary front, whether it's the complainant or the content creator, and then again at the OCC and publisher level as well?
To start with, I think it should be only with the content. So that's just the content. Provide me the content. Tell me the context. Why do you find it objectionable, or you are aggrieved with that piece of material out there? And it should go on there. And if it is not satisfactory at the SRO level, all the grievance officers level, the grievance officer may not call in for a personal hearing, but I think we should move on to the next level where they could actually mediate. In UK, you have what is called the IPSO, which is the International Press Standards Organization, and IMPRESS. Two organizations, self-regulated organizations, came after the Nevison report. The Sun newspaper scandal, where a little girl's phone was tapped. So that led to a huge outcry in the UK, and the government set up this panel called the Nevison Inquiry report. So they have this very nice thing. So there should be a mediation after the grievance, but a hearing should come at the SRO level. It first, the documents and the material has to be scrutinized, and if they think, and they should be calling in for a personal hearing. The person who gives complaint needs to say that. Well, I'm specifically saying that because we've had this instance of one single person filing on an average, about 400 complaints against one particular broadcaster for a few months. So when you're going to call him for a personal hearing, he's never going to turn up, right? So you have these malified intentions, you have corporate wars. So to avoid all those mess, we should have a thing, but only after the scrutiny of the material. Because under the Evidence Act, right, Indian Evidence Act, it does qualify that whatever you submitted is valid under the law. Right? So we should go by the material. If not satisfied, call in the guy to explain why does he think, and then pass an order, whichever way it is.
Right. Do you want to add anything, Arjun?
So on the grievance redressal process, I think if I could set out on the intermediary side, it works as follows: that you set out a complaint, and from getting the complaint, you have 15 days for the body to sort of take that complaint on record and respond to you. There are certain circumstances where actions need to be taken immediately on your behalf. For example, if pictures are of a personal or private nature and they're online, so the timelines for that are a little short. The other situation is obviously when you get a governmental agency or a court order, then you have 36 hours to take action. But outside the government mandated or the court mandated process, if you receive a user complaint, the process is you get a complaint, you acknowledge it, you take action within 15 days. What you can do is you can give the user against whom the decision has been taken an opportunity to respond. And that response opportunity can occur, say, post the action has been taken. So you take the action and you go, okay, you have the next 15 days or 20 days or 30 days to respond to some of this. And you can engage somebody or you can do it by yourself. But these are document-only, largely processes. As for what kind of system will be implemented, I think we will see different systems for different types of bodies. Smaller organizations will need to be leaner, more automated, more streamlined, templatized response systems. As systems go larger, they can, based on the type and nature of complaint, they can give more flexibility and freedom. In fact, Facebook has an oversight board, which is an independent sort of, their own private Supreme Court of experts who sit on key matters and they decide it. And these decisions then set the policy for other actions that are taken. An equally important part of the grievance redressal process is the monthly report that the intermediary will need to publish, because that sort of brings in transparency on how have the rules been applied. Have they been applied consistently? Have they not been applied consistently? Because as these reports start coming out, people will start commenting on these. People will start referring to these, saying, you did this with respect to this person in this scenario. I am facing the same situation. And which is then you will start seeing rules and precedent being set, even though not technically required, but consistency in rule making, its application of the rule is also important. And therefore, you will see processes, systems come in even on the intermediary side.
And what about legal representation? So I understand documents only is the key, like even Jay was saying at level 1. At level 2, you could have either documents only or hearing. But do you foresee at level 2 and level 3 lawyers coming in and representing both the complainants as well as, say, the broadcasters or the OCC or publishers before the SRO?
So this will be more on the news and the OTT side, not so much on the intermediary side. And definitely, I mean, legal representation may play a part or to it, sort of when there is representation or hearings in the committee. If you see the language, it says in the hearing. So the committee is also sort of structured as a body that will sort of hear a grievance and call somebody and ask them for review. So definitely that might happen, but not on the intermediary side so much. I mean, until unless it's an action that's been taken against somebody famous and they want to challenge it, so they may engage somebody to sort of give their responses. But other than that, not so much.
So, but what really happens at the intermediary level, the rules only provide for level 1, which is basically the company's grievance redressal officer. But if I'm a complainant and I'm not satisfied, where do I file an appeal, or what recourse do I have?
So here's the bit, right? If you think you may not be satisfied on 2 counts, right? You're not satisfied because you don't agree with the decision, but then that's it. Right? There is a platform, they have their own rules. They're free to do at the end of the day what they do. The second is you think you're not satisfied because they haven't applied the law that is applicable to them. So if they haven't applied the law, then, and you're an aggrieved party, right? Yeah, in that sense, you can go to the courts and you can say that this is a platform, this is a person who has done X on me with relation to me, because it's not that the platform has ever done anything. Somebody else has done something. And I raised it with this intermediary, and this intermediary did not apply the rule or the law properly as required under the IT rules, and therefore, not only is that person liable for what he's done to me, but here now the platform is also liable, because if you see, I think Rule 13 or 16 will say that if you don't, follow the rules, then you're responsible as well. So, so in that situation, you will see people going and deeper pocket platforms will have deeper pockets. Sorry, Rule 9, right? So Rule 9 will say that if you don't follow sort of these rules, Rule 7 will say if you don't observe these rules, then the protection under Section 79 will not be applicable, and you will be liable for punishment under any law, including the provisions of the Indian Penal Code. So, which is why when platforms take these decisions, they will need to take it carefully. And if not carefully, they will practically err on the side of caution.
Right. Just to add on Arjun's thing, so that that is going to lead a huge flurry of petitions in the court. So what most of our broadcasting organizations have been asking was, give us the statutory power like a tribunal, right? So most of these things, even these rules, when it went to the Supreme Court, the court essentially said it's toothless. These are just guidelines, right? It's not going to be punitive. We are still in the punitive structure of lawmaking on the jurisprudence, right? Not on the reformatory side. But even if you want to take some action, I think the second level should, I'm sure Arjun would agree with me, to reduce the litigations in the court. Come to the SRO level, give the SRO a statutory power. Give us a power where we could penalize people. And penalizing somebody, punishing somebody could be even an apology, right? No content. It's a matter of credibility. It's just not just a fiscal penalty, but when you ask somebody to put out a content which says that I have committed some mistake in the previous content which I made, that's a huge credibility hit, and that directly hits their revenue, right? So and the consumer base. So I think the second level after the grievance officer should be the SRO, and a personal hearing should be given. If the in-person hearing is not feasible because the complaint doesn't turn up, at least a legal representation should be given. And I think we should be given a fair chance of being a statutory organization, right? So you give us a statute and give us the powers to penalize, and we'll report it to you every month. Or are we going to just leave it from the grievance officer, skipping the SR? We have an SR, and then straight away skipping on to the courts, and you're going to have a flurry of applications out there.
Yeah. Thank you, Jay. Just a question to you now, I guess, moving on with the process. I think earlier you mentioned, we have so many different languages in India, different dialects. how do you think the SROs and the IDC will basically navigate across regional languages? If a complaint is made in, say, Telugu, is the decision going to be given in Telugu or in English or in Hindi? And how it basically, the SROs and IDCs reach to rural India?
Oh,
What are
that's
some of the best practices to sort of do that?
you're letting me to open my cards at what we are intending to do or what we'll do. So let's look at we are living in a generation of data, right? What are all these technologies in place? I mean, probably the government just ask. I would happy to engage with the conversation on these rule makers who wrote these rules. You've written the rules. How are you going to actually implement it? India's got one of the finest laws, but we lack in executing it. Right. So that's the practical purpose issue of it at the center of the issue. So let's get into the data. So your 80% of the content is produced and consumed in just 7 languages.
Yeah.
Just 7 languages, right? So it's a top-down approach. Look at those 7 languages, right? Yeah, the smaller languages, I don't say ignore them, but bring everybody on the fold. Look at these 7 languages. What is the kind of content? Bring on the platforms, create an awareness, right? And I think there should be an expert, right? Under the Indian laws, IPC, the CRPC, you have something called an expert witness who would give a opinion on a murder, a forensic fingerprint in terms of a banking fraud or something. So bring in a content expert witness, at least for the OCC, I can tell you, for the news also, for the matter news, maybe a retired editor who could spare his time, who could say, I mean, an editor is like a father figure, right? So he decides what goes out there and what doesn't go in the traditional sense, right? Bring in those experts or bring in a local civil rights activist who could review it and give an independent expert report based on which you could take a decision in English, in the whatever language. But interpreting that language, right, is very, very critical, right? In fact, there was a very interesting case we dealt. That was a litigation somewhere in Punjab. The person got actually arrested for a term which is very colloquial in Uttar Pradesh, but he used it to somebody who's in Punjab. So in Punjab, a person in Punjab would take it as an insult, but in UP it is a colloquial word, right? So that led to a police complaint, that led to an arrest, right? So it is just a matter of context. So I'm talking within the Hindi belt, right? And just within the Hindi belt. So we need to deal with all these complexities. But yeah, so I would suggest an expert member or an expert person which the government should identify or the SRO should identify. We have identified some people in the states where we send the video clip or the content and say, what do you think as an independent person? Does it violate the law? Does it violate ethics? Does it violate editorial standards? And then he gives a report, based on which we could proceed. And the Indian laws, IPC does allow that expert report. And especially for the OCC, I think they could, if the government wants to reduce costs, which they're very keen on, they could actually send it to the censor board chiefs. You have censor board or the film certification board across the country, across languages, right? Send it to them, let them certify or let them put out a report saying that we think it is violative law, violative thing, and then go there. Then you can pass a judgment on that and order on that.
Yeah. Thank you. Just moving on, Arjun. So the rule also talk about the review committee under the Indian Telegraph Rule of 1951. What do you think the role of the review committee will be under these IT rules?
I mean, that's effectively where the statutory power to look at some of these come from. So that's why it's been set out. I think one is obviously one important part will be that they will have the power to issue some of these emergency directions as well, right? And that is where more than something else, a lot of the initial power might be exercised where they see something which is falling foul of Section 69A, and then they exercise that power for blocking. Other is in other aspects, this framework works very largely similar to how it works on the broadcasting, where there is sort of a flow of information from the organization to an industry body to a review body that looks at how the self-regulatory body has been operating, and then it takes certain decisions. The other situation with it, which is unique to this final tier or tier 3 that is there is that it is the body that has the power to ask for modification of content.
Yeah.
Other bodies have the border power to ask for reclassification or sort of asking for censure and things like that. But it is this third level
Yeah.
that will have the power to actually ask modifications, and which as we mentioned earlier will be questioned by some. I mean, by maybe sort of become a matter of litigation soon.
Yeah. Thank you. Just moving on, I guess, from the process and sort of coming back, taking a step back in terms of the grievance redressal process. So we've discussed about, how compliance costs are going to be massive, how basically these rules will apply to pretty much like podcasters or AV content or OCCs, publishers. What are some of the best practices you think that companies should look at when building their grievance redressal process? Should it be completely in-house? Should it be, in collaboration with a third-party provider? Should it be completely externalized to a third-party provider? Both at level 1 and level 2 for the part 3 of the rules, which apply to publishers and OCCs. And obviously at the intermediary level, it's only level 1.
As far as the publishers, I could talk on the publishers side. We would be happy to outsource it to a third-party provider, right? But does the rules allow us to do it? Because the grievance officer, they say it has to be an in-house, or they've at least indirectly said. But I think there should be some flexibility on allowing it to get it to a third-party provider, right? Because the third-party provider, though, in terms of content privacy and a whole lot of stuff, but you'll be handling about 4 or 5 clients, right? And it is just to control costs, the compliance expenses, as I would call it. It's better to have a shared services, right? So if a third-party provider can tell me, what, an X company, he may not mention who's the publisher, but it's an X company had a similar complaint, right? Or the Y company had a similar grievance, right? Or there's this person, like I told you, one person filed about 400 complaints in a week. We got to know because it's not only with us, he's filed with other people also. His job is just to file a grievance at the behest of somebody. He's not doing it very genuinely, right? So identify them, identify the web Nyaya platforms, and a couple of other platforms are very good at that. So we would be happy to go to a third party with somebody with an oversight within the company signing off. Because the compliance officer always has to be somebody who's an employee of the company.
Of course.
The process can be done, but come back to me, I'll review it, sign it, and report to the government or report to the person who's raising the grievance. Right, who has to be addressed. That's probably a hybrid model to start with, because the kind of large numbers we are going to look at, and the content producers, the platforms, as well as the cost that would address largely, the government should look at. I mean, we should look at actually a third-party provider, but have somebody internally who could actually review and say, okay, I'm happy to sign on those dotted lines. Arjun, your thoughts.
On the intermediary side, definitely just for things like managing ticketing of the complaints, sending out, ensuring everybody is keeping to the time prescribed by law, just making sure here, this has been pending for 13 days, time is up in 15. A lot of systems and processes can easily be managed by outside service providers. And maybe similarly with OTT players, I think a lot of the mechanics will need, instead of people just developing their own independent technologies, if you have a open solution, it really helps.
And what about at the level 2, Arjun?
Definitely, I mean, any organization needs a secretariat, and sort of helping technology only helps bring in efficiency to the role of the secretariat. So, in fact, I think over time it will also help you identify, what are the past decisions you've taken in situations like this. So, if you're, deviating from previous decisions, I mean, but then that's only when data sets increase and the technology also improves.
Thank you.
Let's look at this data mining, right, of the third-party providers, I would say. So I think we should have this artificial intelligence and a lot of data mining on that, right? So as I told you, there could be sharing of best practices among industry players. One thing, and let's even for the complaint redressal from zero, from where the aggrieved person raises a ticket, the first level. But when it comes to an SRO, what does he need to do? He again needs to file the complaint, again needs to provide the proof. That's not required, right? So you can have a single thing. And for a last compliance thing, I would be happy to give an access to the joint secretary or whoever is I'm reporting into at the ministry and say, you can do it only at read-only mode. You can't write it, you can't edit it, but this is what it happens. So he has an entire digital trail, right? We all leave digital trails somewhere or the other to today, which can never be erased, right? A single platform, a third-party provider with a compliance officer inside and the SRO. That's my personal wish. I wish it happens. So I'll be happy to do that.
Thank you, Jay. Just coming back to a point you mentioned earlier, I guess funding the SRO at the publisher and OCC level. What would you say should be, best practices, or what should companies essentially follow or do? How should they fund the SRO, and how should they fund the entire grievance redressal compliance costs? Do you think a complainant should also be paying a cost when they're registering a complaint or filing an appeal at level 2, or should it just be the SRO absorbing the cost through its members?
So that's a very, very tricky question, because if I'm going to charge the complainant, I'll answer your second question first. Charge the complaint, filing complaint, I'm going to reduce the number of grievances. Paying up is something which we are not used to getting, paying for something, right? We have a lot of free content, but we don't want to file a complaint. But I think there should be a cost, right? Personally, I think there should be a cost, because that will actually reduce the frivolous complaints. Let's look at the Indian codes. If there's a frivolous complaint, there's a cost to the petitioner. But under the law, he needs to pay up, right? Or whatever the wasting the court's time. But here, how are you going to ensure this guy pays up, right? One. On the other side, to set up the SRO, yes, the platforms can self-fund it. But over a period of time, it has to be completely independent. Because if I'm going to be funded by somebody, this is a very interesting conversation we had a couple of weeks ago, was if I'm being funded by a platform who's tomorrow found violative, right? Number one, is he going to continue the funding? Number two, what happens if he walks out? And he's not, because SRO is a self-regulatory organization, is typically a voluntary thing, right? So am I actually paying up? Just imagine you're going to go pay up and support somebody, build an organization for him to come and say that you're wrong, right? This is this critical factor that SROs have not taken up in India.
Yeah.
So an alternate model is what the UK has adopted. What they put in, what is the compliance cost? A percentage of your fee, of your revenue, is taken as a what is called the ethics or the content regulation fee. That's run by a regulatory funding company, RFC, which is independent, with an oversight by the government, and they fund the SROs. That's the typical UK model which works. And that's not something which happened in 2011-12 with the Lord Nevison report. But India, the Press Council of India acts upon the same model.
Yeah,
they charge a percentage of the fee, right? Which is routed through the government. If as a private organization, I'm going to ask them, it's not going to happen. But it could be anything. So let's understand what the content industry is about. Close to $60-70 billion. Even a 0.01% is $100 million is quite a large amount.
Yeah.
Right. So for running even a 5-6 SROs, that's sufficient enough. That's perfectly sufficient enough. A fraction. 0.01, 0.25, what do we charge it? But that should be opened up for a public consultation. Yeah. Let's see what these guys are actually ready to pay up.
Yeah.
Right, and sell it out, and but it has to be independent. Maybe 2-3 years they should look at a very independent SRO, so that they don't get influenced by the funder to give a favorable order.
Yeah, no, that's very interesting. Just coming back to the first point that you mentioned in terms of putting costs on frivolous complaints, do you think a mechanism where you charge the complainant when he files, but you keep that money on hold and not charge it until the decision is out? And if the SRO says this is actually a frivolous complaint and the money should be forfeited, then the actual platform forfeits the money and passes it on to the SRO. But if the decision is that, the complaint wasn't frivolous, then the money is just credited back to the account. Just some sort of hybrid model. Do you think
That is, but what is that amount going to be? So is that issue, right? How much are you going to charge? Is typically it's going to be the issue. Is it worth the effort, right? Let us look at the court fees today, right? It's in fractions today. It's literally in fractions. I mean, Arjun would vouch for it. Is it worth my effort to hold that money in an escrow account, put that effort, return it back, right? I don't think so. Unless if it is a legal claim on a damages, fine. The Bombay High Court has things saying that you'll have to pay. I mean, if Arjun can correct me, a part of the fee, right? We claim about 10 crores, 5 crores you deposit into the account, then you go challenge it, right? So with that, is that the kind of money people are ready to put in? I'm not sure. But what is that going to be? Fee going to be, but is it worth my effort?
Yeah.
Right. But yes, definitely it will act as a deterrent for frivolous complaints, and people would actually think twice. They will go through it. It reduces my job, right? So I don't want to handle thousands of complaints. You'll have seriousness in the grievance process.
Yeah.
Right. So that's for sure. But what amount should we do it in escrow? We should, but I think a couple of us should actually try it out.
Yeah.
Try it out for a couple of months and say whether it works.
Yeah.
SRO itself is a work in progress in India.
Of course, yeah.
We should actually try this hybrid model. I'll take that idea from you.
Yeah.
We'll try and roll out this hybrid model and let's see how it works. If it works, it works. It's good.
Yeah. Arjun, did you have any thoughts on that?
No, I mean, here's a bit, right? It's a fairly tight timeline that they've set out under the rules, under both frameworks, whether it's for the intermediaries or for the publishers. And organizations have costs too, especially if you have to meet these really tight deadlines. And as nobody's ever discussed this before, but Jay has, which is your content code says that you broadcast something, please give a complaint within 7 days or 3 days of you broadcasting it. Here, Mughal Azam might have been shot many years ago, but it came on one OTT player last week, and you saw it, and you found something problematic, and you raised a complaint. So the scope of this is much larger. The amount of information you're dealing with is much larger. Yeah. And if you don't find a practical way to fund some of this, whether through sort of consumer rights groups, maximum complaints, ask them to take donations, then it will be difficult to meaningfully run this organization, right?
Yeah. I would be happy if they could add it in the CSR code.
Yeah, maybe.
I mean, just say 1%, 2%. It's already defined, right? CSR code today says that X amount, percentage of the CSR funds has to be spent on these things.
Or, many people might ask that, is that worth, CSR funds being spent for?
Oh, give me a savings, right? As a broadcaster, give me a saving. Tell me if I set aside X amount for what I would call not just the SRO, but I would call the consumer and an audience awareness, right? I'm happy to take a couple of hundred people on a picnic to one of my studios and say, this is how our content produced. This is how we show you on television, right? For the consumer awareness. Let's not look at only the complaint and the redressal process. Look at how you can reduce those complaints.
Course,
right? Yeah. How can you create those consumer awareness and viewers awareness? Let's do that. But if they say, okay, I can spend up to 1% of my net profit weighted average over the last 3 years, I spent on it, on the SRO plus the consumer awareness, I'm exempt. There is no incentive to be a good guy in this country. So that is what we need to look at. This law, it's very, very important, right? So you'll have to look at how do you incentivize the guy to be good. Yeah. Not try and catch him and say, there's a complaint, I'm going to hang you, take you to the court, set up a process, address the complaint. But how do you reduce the complaint?
Yeah.
Right. So are you going to introduce that carrot to make the guy a good producer? Right. That's important. That's what we should look at in this law.
No, that's very interesting. Thank you, Jay. I'm just going to move on to the last topic, and I think Jay briefly touched upon it. It's basically introducing pre-litigation mediation and or even arbitration in this process. And I know it's not strictly contemplated under the IT rules, but I wanted to get the panelists' thought on what they think and how they could fit in, say, mediation, the existing grievance redressal process, or arbitration to sort of resolve disputes.
In my personal view, if you think what the rules are, prescribed, and the framework that is prescribed is not sufficient for you and you want more, then there's a cost attached to it.
Yeah.
And if somebody sort of, an organization or a body provides that solution for that cost, and a member says, okay, you know what, I'm happy to take a look at this, then that might be the situation. The other place where actually it might be more sort of frequently used is when a member has a concern with the decision taken by the SRO.
Right.
Again, for something that they've published, which is where it is more likely when something like this will be invoked. But I don't know how that might work in this current framework, because the current framework says, 15 days to the publisher, then 15 days to the SRO, and if you're not happy, then 15 days to sort of the oversight mechanism. And the power is given to the complainant. There's maybe they can be sort of relook and tweaking it, and even giving a power to the person against whom the complaint is made, saying, I'm not happy with this SRO's decision, I want to challenge it. And if the complainant, all the facts are on record, these are esteemed people who are taking this decision, I want to make my views. If the complainant deems fit, they can write in a response, or they can have representation here in this place and take a call. So that could well be it.
Yeah, let's touch upon how the UK, again going back to the Nevison report and the two organizations called IPSO and Impress, they have a must mediation clause, right? Before the SRO takes up, the judge takes up, the complainant and the media or the content producer on the platform have to sit and mediate. They'll have to arrive at a mutual agreeable solution.
Yeah.
That is, I think, see, we say it or leave it. Once the Supreme Court order comes in the next Chief Justice is going to be there, he's anyway going to pronounce it. Pre-litigation mediation and arbitration is going to be the rule of the land. You leave it or take it, you don't have a choice. So why can't we stick our neck out and do it today? I mean, do you want a law today, which been with the rules coming in today, and then anyway, it's in the courts, and then might as well do it now. Let's put that must mediation clause. Well, there is a cost attached to it, definitely, right? So even that cost can fund the SRO, right? The cost can fund the lawyers on the two sides or the party, and then again, it's going to be only serious complaints which are going to go here, right? So I think that is very crucial. I'm in favor of an arbitration and a mediation before it goes to the SRO, right? So that's a very crucial thing which we should look at.
Thank you, Jay. Just my final question: are you aware of any SROs that have been set up or are being set up under these rules by the OTT platforms or by publishers?
Right. So the first one was the Press Council, as well as it was an industry-run organization with an oversight by the government as early as the late 70s, and then we had the Broadcast Content Complaints Council, which is what the general entertainment channels, which is run by an organization called Indian Broadcasting Foundation, which is a trade body of all the entertainment television channels. Then you have the NBA, my counterpart, which is a News Broadcasters Association, running what is called the News Broadcasters Standards Organization.
Yeah.
Then we come into the picture, News Broadcasters Federation. We are setting up our own SRO. So the SRO is always a part and parcel of an industry. And then you have the DNPPA, which is the Digital News Producers Association, which is a body of the traditional media companies. The India Today, Hindu Times of India, they got together and they launched a thing. And today, as we talk, I just got a message, they've launched their SRO, right? With one of the eminent members being Jawad Sirkar, who used to be the chairman of Prasar Bharati. Then you have the IDMA, which is again a sister organization of ours, which is the Indian Digital Media Association. So that will also have an SRO. In fact, one of the ideas which I propounded here is the sharing the SRO. So IDMA and us might explore at looking at having one single SRO. Right? Because it's the same rules, right? It's the same rules, same IPC, CRPC. We have the requirements of the judge and everything already in place. So that's there. There is one more which is called DigiPub, Digital Publishers, which is a digital-only media companies which is your scroll, wire, print, news minute, who have actually got to the Kerala High Court and the Supreme Court challenging these rules under or preventing any course of action. Then you have the OCCC, Online Curated Content Committee or Court, which is by most of the OTT players. I think the last were about 13 or 16 of them, which is the Hotstar, Viacom, Amazon Prime. I'm not sure whether Amazon Prime is still on board. Then you have MX Player from Times of India. Again, Viacom 18 had this Voot. All these people got together and they started their under an industry called the IMAI, which is the Internet and Mobile Association of India. So there are already a bunch of them, and we do expect some more to come in.
Okay.
Right. So that's why I said most of them can actually share the cost of an SRO rather than setting up each one of them, right? Because the laws are going to be the same, unless if they want to be regulated differently, which may or may not end up in the courts of law.
True. Okay, thank you so much, Jay. Thank you so much, Arjun. I don't know if there are any questions from the audience. I guess we can take them now. But otherwise, I think that's the end of today's webinar. Thank you, everyone, for attending. The recording would be available on YouTube. And if there are any queries or if you want a copy of the slides, please feel free to email me. And I'll see you again on the last Friday of April. So that's 30th April at 5 p.m. With some fresh updates on arbitration mediation and a new panel discussion.
Thanks a lot for the opportunity, Vishwam and the other team. I'm happy to answer any questions, even if it is offline. Right? Thank you.
Thank you, Arjun.
Thank you, Arjun, for joining me.
I'll request Chaitanya now to end this webinar.
Yes, thank you, sir. Thank you, Krishna, sir. Thank you, Arjun, sir, for sharing your views on the updates and the new recent IT rules. So participants, this brings us to the end of today's session. See you all in the next session. Till then, stay home, stay safe, goodbye and take care. Thank you.
Thank you all. Bye.